1 minute past midnight, July 24th. America's 10% tariff on nearly everything it imports died. Not struck down, not repealed, expired. That same week, the government was handing tariffs back. $100 billion returned by late July, of $166 billion collected under a law the Supreme Court says never allowed them. Courts took America's tariff wall apart twice this year. The calendar took it apart a third time. And the wall is still standing, because at that same minute past midnight, a replacement took effect. Three things then: what the Supreme Court actually killed, and where the money goes; the stopgap that died on a timer, and what's being built instead: a different kind of wall entirely. Ground rule, as always: information and analysis, not financial advice, no recommendations. Start with February 20th. In a case called Learning Resources versus Trump, the Supreme Court ruled, 6 votes to 3, that the emergency powers law behind the 2025 tariffs, the International Emergency Economic Powers Act, does not authorize tariffs at all. The reasoning matters because it tells you what survives. The law lets a president regulate importation in an emergency. The court read that text and found no tariffs in it, no duties, and held that when Congress hands over a power that big, it says so plainly. This is not a ruling that tariffs are bad policy. It's about which door you have to use. Now, the full ledger. Since January of 2025, the new tariffs raised about $284 billion gross. The emergency law share is going back. The refund pipeline opened in the spring. But note the asterisk. The government is separately appealing how far back those refunds must reach, so part of that money is itself still in court. Worth sitting with. Importers paid those duties, and many passed them on. The refunds go to the importers of record, not to anyone downstream who ate the cost in a price. Where the money finally lands will take years to settle. 4 days after the ruling, the White House reached for a different door. Section 122 of the Trade Act, a 1974 statute that allows up to 15% for 150 days. No court sign-off required. On February 24th, a flat 10% landed on nearly all imports. One catch: the statute is written for balance of payments emergencies. On May 7th, the Court of International Trade struck that one down too. A trade deficit, it held, is not a balance of payments deficit within the meaning of the statute. Then 2 details that tell you how this actually works. The ruling protected only 3 of the plaintiffs, the 3 importers who sued. Everyone else kept paying. And in June, the appeals court paused even that narrow win while the government appeals. So those 5 months of surcharge money sit outside the refund entirely, frozen until the appeal lands. Nobody can tell you today whether it comes back. The courts never finished the job. The calendar did. 150 days from February 24th is July 24th. Congress passed no extension, and the surcharge simply ceased to exist. Same minute, same day, the replacement arrived. New duties under Section 301, the Trade Retaliation Authority. 60 trading partners, more than 99% of everything America imports. The stated grounds this time: those countries' failure to police goods made with forced labor. 10% on one group: Canada, Mexico, India, Britain among them. 12.5% on most of the rest, including China and Vietnam. For Japan, Korea, and the European Union, the new duties mostly top up to a combined level rather than stack. Squint, and it's the old surcharge on a new legal foundation. And the wall almost grew again. A 50% duty on Canadian cars, dairy, and alcohol, under Section 338, a 1930 statute never used before, was set to land on August 19th. It was paused 90 minutes short, with the deal still unsigned. 3 days on the clock, and then it lands, or it's dead. And it isn't alone. Under Section 232, the National Security Authority, steel and aluminum have carried 50% since the middle of last year. On July 31st, patented pharmaceuticals picked up a duty of 100%. The consumer catch is smaller than it sounds. Generics. 9 of every 10 American prescriptions are excluded. Allied countries pay 15%, and drug makers with pricing deals or American factory commitments are largely spared. Step back, and the structure looks less like a revenue line than a lever. Here's the structural difference. The old wall was one statute stretched over everything, and it lost twice in court. The new one is built from authorities that have survived decades of litigation. The China tariffs of 2018 ran on Section 301. The steel tariffs ran on Section 232. Both still stand. And none of this carries a rate ceiling or a 150-day clock. Put one number on it. Penn Wharton tracks the effective tariff rate, duties actually collected, against what's actually imported. January of 2025, 2.3%. It climbed through last year. Then came the ruling, and by June, the latest month on the books, it was down to 7.1. Their own note on the decline. It follows the February decision, but the average hides the shape. In June, steel and aluminum imports carried about 41%, goods from China about 23%, autos about 13%. And what nobody can show you yet, June ends before the surcharge expired, before the 60-country duties, before pharma. The first month of the rebuilt wall hasn't printed. That number is where this story goes next. So, base case, the tariff wall is permanent, but it's a different wall. Lower on average than at the peak, much higher in specific places, and rebuilt on statutes designed to survive review. Refunds keep flowing on the emergency law money. The surcharge money stays frozen until the appeal. 3 things would change that picture. 1. The appeals court. The Federal Circuit now holds 2 tariff cases, whether the surcharge was legal and how far the refunds must reach. If the surcharge ruling is affirmed, 5 months of collections join the refund queue, and that tool can't be used this way again. If it's reversed, a 150-day tariff goes back on the shelf. Opposite worlds, no date scheduled. 2. September 29th. The grace period ends for the last group of drug makers under the pharma duty. Watch whether the pricing deals and factory commitments hold, or the carve-outs quietly multiply. A tariff that's all exceptions is a negotiation. One that bites is policy. 3. The July and August prints of that effective rate. If the rebuilt wall pushes the average back toward its peak, the base case is wrong. The courts changed the paperwork, not the price. If it holds near 7, this year's story is a tariff that got narrower and deeper at once. The watch list, then. One appeals court holding 2 cases, one date at the end of September and one monthly number. Not a signal to do anything, just where this actually gets decided. A year of emergency tariffs, voided. A stopgap, expired. Refunds measured in the hundreds of billions, in motion. And an average import tax still roughly 3 times what it was at the start of last year. All of it true at once, and that's the point. If you want the version of these stories that survives a fact check, subscribe. That's the entire operating principle here. Next time, the Federal Reserve was leaning toward a rate hike. Then the economy shed 23,000 jobs. September's meeting just got a lot harder to call. And once more, information and analysis only, not financial advice. We don't tell you to buy or sell anything.